Madam Magistrate, would you please call the case?
Good afternoon, Your Honours. This is case number IT 0484R77.1S, the prosecutor versus Mr Kobashi.
Thank you, Madam Magistrate. Could I have the appearances? Prosecution first.
Good afternoon, Your Honours. Joanna Corner, assisted by Alma Imamovich Ivanov for the prosecution.
Thank you, Ms. Corner. For the defense.
Good afternoon, Your Honours. Michael Carnavaz for Mr Kobashi.
Yes, and I see that Mr. Kabashi is present as well. You find a newly composed bench before you after Judges Molotto and Delvar had recused themselves last week. The president, the vice president of this, the acting president of this tribunal has assigned Judge Kwan and Judge Morrison to this case, and that's the newly composed bench you see before you. Mr. Kabashi, during your further appearance on the 26th of August 2011, you have pleaded guilty to the indictment against you. And pursuant to the rules of procedure and evidence, the trial chamber must be satisfied of a number of requirements before accepting your guilty plea and entering a finding of guilt. Therefore, there may be some questions to you. Could I ask my colleagues whether they have any questions?
Not at this juncture.
Not at this moment. Judge Kwan, any questions?
Mr. Kabashi, I just want to check with you that whether you understand that by pleading guilty you may sentence up to 7 years of imprisonment.
Oh.
Yes.
Thank you.
I don't know how I'm sorry, I don't know how you all intend to proceed, but I was wondering if it would assist if I were to open the facts first, because there's been no pre-trial brief or anything in this case, because it was all dealt with fairly quickly.
Yes, I know that. Now, usually a pre-trial brief introduces this stage of the proceedings where evidence is heard before you come to a finding of guilt. So therefore, if there are any relevant facts for sentencing, then of course you could present them after there's a finding of guilt. If it does not, if the chamber finally does not enter a finding of guilt, then of course we would have to see how to proceed in relation to facts and law.
Right. Your Honour, can I say that I'm a novice at this? This is the first time that any accused that I've been in a case I've been in, where there's been a plea of guilty. But I was just wondering whether for the purposes of deciding what Your Honours have to decide under the rules, whether this is an informed plea of guilty, Mr Kobashi and indeed the public should hear a brief summary of the facts. That's all.
Yes. Let's then do the following. Let us ask the questions we'd like to ask from Mr. Kobashi, or perhaps even from the parties, and then, but let me just confer with my colleagues. The Chamber will then give you an opportunity to further make further submissions in relation to the requirements under Rule 62 bis. That includes the factual basis for a finding of guilt. Yes, the one and only question I would have for the parties is Rule 62 bis requires the Chamber to satisfy itself that there is a factual basis for the guilty plea. May I take it that where the party seems not to disagree on this, that this is the factual basis is found in the transcripts of the hearings in which, as alleged by the prosecution now, Mr. Kabashi failed to answer questions, contumaciously failed to answer questions.
Oh, that's right.
And that's for you the factual basis as well, Mr.
Mr. President, Mr. Kabashi has indicated that he was unable to, so effectively that would be contumaciously a refusal.
Yes, that's the reason why I said as alleged by the prosecution. The guilty plea, of course, and then we come to how informed it is. The guilty plea is a guilty plea to the charges as brought against Mr. Kabashi, and that is he failed contumaciously, or he refused or failed contumaciously to answer any questions. So if he now says, I couldn't, I didn't decide that for myself, then of course the question arises to what extent the guilty plea is informed. And if you want to discuss that with your client,
well,
but of course later to hear that it was not contumaciously would contradict the guilty plea.
No, I understand, Mr. President. Mr. Kabashi has indicated over and over again that he was unable to answer the questions, not that he did not want to answer the questions. He also understands the exposure that he's facing. Now, had we been in the United States, I would be entering some sort of a plea where he's entitled to maintain his innocence while at the same time pleading guilty, something that is that's done usually in death penalty cases, where somebody pleads guilty even though they maintain their innocence in order to avoid a death sentence, and instead serves a life sentence.
Yes.
If we look at the way the charge as drafted by the prosecution, we believe that Mr. Kabashi recognizes that his failure to answer the questions amounts to a contumacious failure, because he was repeatedly asked to answer certain questions. Now, we do think that there are mitigating circumstances which go into the sentencing phase.
Yes, I see your point. Let me just confer with my colleagues.
Before that, Mr. Carnavas, because I'm new to this case, I wonder whether your client has explained to the chamber why he was unable to give answers.
Judge Kwan, I was going to go into that over and over again in his prior testimony. When he attempted to explain, he did to some extent explain to the best that he could. And again, he explained only last week before the retrial in Haradinai. But if I could just summarize the points, if we go through the transcripts.
Mr. Carnavas, if you would allow me to just briefly confer with my colleagues. Mr. Carnavas, you may continue your explanation, but let me just briefly express the concerns of the Chamber about whether this is an unequivocal guilty plea. That's the issue that may arise. But if you'd like to continue to answer the question put to you by Judge Kwan, please do so.
Very well. And before I get to continuing my answer to Judge Kwan, if you look at Your Honor's Rule 77A, little I, it says refuses or fails, or fails. So we are suggesting that there was a failure, but not a refusal.
Mr. Carnavas, I think you plead guilty to charges brought against you and not to an article of the rules. And I think the count that was read to Mr. Kobashi when he did enter his guilty pleas were the counts as we find them in the indictment. It says
or failed, refused or failed.
Yes, you'd say contumaciously is not related to failed. It's contumaciously refused or failed.
Or failed.
Not contumaciously failed.
No, what I'm saying, Your Honor, is that he didn't refuse, he failed. He contumaciously failed, but didn't because he has that option. There's the option provided. It's it's not and, it's or.
Yes, but you say he contumaciously failed.
Yes.
Not failed, but contumaciously failed.
With all due respect, Your Honor, I fail to understand exactly what you're driving at. He failed. He failed in a sense that, not that he refused. That's the end. That if we go through the transcript, he's repeatedly telling you, Judge Ori, that it's not that he does not want to, but that he cannot, that he's unable to. And that's why we're saying that there was a failure on his part.
I will let you answer. I will let you continue to answer the question put to you by Judge Kwon, and to what extent the problem then remains is. We'll consider that. Please proceed.
Thank you. Judge Kwon, if we look at the transcript of 5 June 2007, and there are some passages that I was going to go through in my sentencing remarks, we will see over and over again Mr. Kabashi saying the various reasons why he's unable. One, he talks about there are effectively no protective measures because he's aware of instances where witnesses, things happen to witnesses. He talks about that on more than one occasion. He talks about the fact that in the past he's provided information to the United Nations investigators, to ICTY investigators, and that information was never followed up on. In other words, when he did so, which was when Kosovo was very, very dangerous, he stepped forward, provided information to the Kosovo police, the UN, the UNVIC investigators there, and the ICTY investigators, where he pointed out names and places where they could find bodies and what have you, and nothing was done. And in effect, he risked his life in providing this information. He testified in Lima. It became well known that he had testified. He also describes that when he did provide a statement, because he provided a statement in 2004 twice, and then again the second statement that was for the Haradinaj case, he was very disenchanted with the way the statement was cobbled together. He was asked questions, they're not tape recorded, he's provided with a summary, and the summary has all sorts of problems, factual problems. And in his opinion, unfortunately and regrettably, he drew the conclusion that the investigators were trying to summarize or to provide a summary of his statement that suited their purpose as opposed to what he had actually said. Now, I think what normally happens is that when statements are given, it's very difficult to summarize, and sometimes mistakes are made. And they're made not intentionally, but honestly. The problem, however, is that when it's read back, it's usually months or years later, because the statement is provided in Albanian, and it's not until they're about to come here and give evidence that they now see it in their own language, and they're able to see the errors. So that was one of the other reasons why he was disenchanted. He was also disenchanted with the entire process because he felt, as I indicated, one, investigations weren't conducted. Two, where he was held in prison for 3.5 years, or close to 3.5 years, he was tortured, and eventually there was a massacre, and that wasn't prosecuted by the ICTY. And he was never asked about it. I understand it was in the indictment. I understand Judge Bonomi cut it off. But imagine deleting with just one button an event where hundreds of people were slaughtered. And this was one of the other things that caused them concern. But when we look at what he's saying, there are a lot of different things that are in his mind. He doesn't quite come out and say that he is afraid for himself. In fact, he says the opposite. But on the other hand, he talks about other witnesses being killed. Other witnesses who have provided evidence. Now, recently when he was asked in the Haradinaj 2 whether he was afraid for himself, he indicated no. When he was asked about his family members And we have to keep in mind that he has a mother, he's got a father, he's got a sister with 6 kids, and he's got a sister with 2 kids living in Kosovo. The answer to that question was, I don't know. Now, I ask yourselves, Your Honors, to place yourself in his position when answering these sorts of questions. And the best that he's able to say is that he's unable, he was unable back then, and he's unable right now to testify. He came here knowing that he would be arrested upon arrival. He left his 2-week-old baby boy to come here, hoping that he would be able to find the strength to testify. But he also suffers, as we know, from post-traumatic stress disorder, and that's the other impediment, that when he comes into court, he has a physical disability. He's incapable of thinking clearly, and he has he's overcome by emotions, and that's the other reason why he finds it extremely difficult to answer very simple questions. And unfortunately, he's never been treated. He's never been even evaluated up until I suggested that he be evaluated at the UNDU. So that's, I trust I've answered your question, Judge Kwan.
Just one clarification, Mr. Khan.
Gjykatësi Kwan, një sqarim zot.
The first reason you referred to is page 6, line 17. One, he talks about there are effectively no protective measures. But was it not upon his request that the protective measures were rescinded?
Good question, Judge Kwan. Very good, excellent question. In the Limai, he had protective measures, and yet the entire world knew that he testified in Limai. Realistically speaking, okay, anybody who works in the defense at least knows that protective measures effectively never work. We know that because the moment somebody leaves this courtroom, they have access to telephones and access to visits. And no matter how hard we try, and no matter how many admonitions you give, the fact of the matter is that the protective measures don't always work. And the fact that it was well known, not only what he said, but the fact that he had said it. If you look at his testimony, I'll point out exactly, Your Honors, back in an open session, 5 June 2007, on pages 5437 and 5438, he indicates, answer, I was given this statement for a readback on Friday in the afternoon when I just flew back from the United States of America, and I did not pay attention. I was not in a state to pay that much attention to the readback. But the purpose was for me to come back here and explain to the judges that there are no conditions for witnesses to come here and testify. That's why, again, I would like to call to the trial chamber to alleviate me from giving a statement because I'm not in a position to give evidence. I have many explanations, facts to explain. The judge interrupted me, didn't allow me to explain, but I would like to explain those facts because I'm the one who lives in Kosovo. I'm the one who has gone through a lot during the war, and I'm the one who's brought here to tell the truth about things that I saw, heard, somebody else, and so on. Then he goes on, and I can find all, and this is exactly what I intend to do this afternoon, go through all these various passages. Because what effectively he's saying is that there are no protective measures, regrettably. And that here's a man who risked his life initially to give evidence. And now he's being treated like a criminal. This is how he feels today. He goes on to say, on the same page, yes, Your Honors, it is true, it is our duty, but within the framework of a normal life. Since this normal life does not exist in the state where I live, where people get killed, and to nowadays the reasons why they got killed are not known, when lives of people have changed, I don't know in what conditions I can give a statement here. I cannot accommodate myself to give this statement here because of the things that I went through. He's talking about the situation in Kosovo. And so we have to place ourselves in Kosovo. He doesn't have, any protection, or his family doesn't have, even though he doesn't live in Kosovo. He does, as I indicated, have a father, a mother, sisters, nieces, and other family members.
Mr. Conover, I understand your point, and then those matters may well be the matters you deal with as a sentencing circumstances. But I also wonder whether your submission would amount to saying that your client lacks mens rea.
Perhaps before you answer that question, Mr. Carnavas, I'd like to add the following. I'm not a native English-speaking person, so therefore I immediately use my computer to find out what the explanation was of contumaciously. Contumacious is described as obstinate, stubbornly disobedient, persistently, willfully, or overtly defiant of authority. And if you are referring to Rule 77 and refer to the word fails, may I then also draw your attention, perhaps you address that in your answer as well, that in 77A, which does not exhaustively list anything but gives the general description of contempt of the tribunal, those who knowingly and willfully interfere with its administration of justice, including a person, and then contumaciously refuses or fails to answer a question. I understand, but it's the analysis, my provisional analysis of what contempt means in this tribunal, that the failure to answer a question should be contumaciously, and at the same time is an example of knowingly and willfully interfering with the administration of justice. So if someone fails to answer a question because he feigns, or if he fails to answer a question because he totally doesn't understand the question, or there may be, I would say, non-intentional failures to answer questions. But that, as far as I'm concerned at this moment, seems not to be covered by Rule 77, and also is, but I'm addressing Ms. Corner, was not charged a kind of a failure which was not contumacious or was not willfully. I think the charges, as they are formulated, require a mens rea of intent.
Oh, yeah. Your Honour, let there be no mistake. The charge and the way the prosecution put the case is that it was a willful refusal to answer questions.
Or failure.
Or failure. But that whatever contumacious may mean, which is a very, very old-fashioned term indeed, Your Honour, so I'm not surprised you had to look it up, and how it got into the rules is something of a mystery. But it means effectively a willful refusal.
Yes. I think
that's consistent with my earlier dissent on the meaning of consummation.
Yes. Mr. Carnavas, you've heard now a lot of elements which together make one big question, I think. Would you please...
Can I add to that?
Yes, Judge Morrison would like to add something to that as well, to make it even more complex.
Yes. Well, I'm hopefully cut a bit of the Gordian knot. Do you accept, and does your client accept, that contumacious attaches both to a refusal and a failure?
Yes, Your Honor.
Right. It may be that a refusal to answer questions is an overt act where somebody, when asked a question, says, I will not answer that question, or no, I will not answer that question. And a failure to answer a question may be simply staying mute, not saying anything at all, a complete failure to make any explanation of any nature. Now, if contumacious is archaic, this is certainly archaic. In English common law, one could be mute of malice or mute by visitation of God. If you're mute of malice, then you'd be contumacious. If you're mute by visitation of God, then things are out of your hand. You're suffering some disability over which you have no control, ergo no mens rea. Do you accept on behalf of your client that he had a requisite mens rea to contumaciously fail, in the sense that he made a deliberate choice not to answer the question for whatever reasons that he may later give in mitigation?
Yes, Your Honor.
At the same time, I would very much like to verify this also with Mr. Kabashi, because if it takes lawyers close to half an hour to discuss these matters, I think that it would be important for us to know, Mr. Kabashi, whether you accept that by your guilty plea that you have pleaded guilty to a deliberate choice not to answer question for whatever reasons you may have had, but that it was not that you had a inability which did not allow you to answer the question, so that it was your decision not to answer the questions, again for good or bad reasons, but do you accept that to be your part of your guilty plea? If you want to consult with counsel, you may do so.
Thank you, Mr. President.
Yes.
Yes, I think I nevertheless give you an opportunity, although the witness has answered the question too. The answer remains yes, even after having consulted your counsel,
Yes.
Mr. Kabashi. Yes. I think under those circumstances, the Chamber has satisfied itself that the guilty plea has been made voluntarily, that, as we now can establish, that it was informed, that it's not equivocal, and that there is a sufficient factual basis for this offence, this crime, and the accused participation in it. Therefore, the Chamber enters a finding of guilt, on two counts. Count one, contempt of the tribunal, punishable under the tribunal's inherent powers, and consisting of being a witness before a chamber in the case of Prosecutor versus Ramos Haradinaj, Idris Balai, and Lahi Brahimai, that you have contumaciously refused or failed to answer a question committed on the 5th of June 2007 in The Hague. And we also enter a finding of guilt on count 2. In count 2, you were charged with having committed on the 20th of November 2007 when testifying through a video link, therefore being a witness before a chamber in the case of Prosecution versus Ramos Haradinaj, Idris Balai, and Lahi Brahimai, that you have contumaciously refused or failed to answer a question. It is on this basis that we will proceed. Now I have done something, Ms. Corner, which I think I promised that you would have an opportunity to say something more about the facts. Now that seems to be relevant for sentencing as well. I apologize for having entered a finding of guilt already on the charges without having given you an opportunity, as I promised, to make further submissions. Are you ready to make submissions, and perhaps include in your submissions what you had on your mind in relation to sentencing?
Yes, Your Honours, the only thing that I was going to do was effectively briefly open the facts of the matter to you, so you can see the basis on which the prosecution brought the case against the accused. As I indicated last week, we have virtually no submissions to make on sentence. We leave that to the trial chamber.
Then you have an opportunity to do that now. Please proceed.
Your Honours, then briefly, the accused, Mr Kobashi, was born on the 1st of July 1976, so he's now aged 35, in Zahak in Kosovo, and as Your Honours know, he's a Kosovo Albanian. He apparently joined the KLA in April of 1998, and on the 22nd of December of 1998, he and the other members of his family were arrested by the Serb forces at their home. He was imprisoned first in a place called Peja, then Dubrava, and finally in Nis in Serbia. And in fact, he was only released on the 27th of March of 2002, so altogether he spent a little over 3 years, 3.5 years, or 3.25 years, as a prisoner of the Serbs. After his release, according to his own evidence, he worked in the construction industry, then he joined the Kosovo police, and finally left and went to the United States, where he now resides and works managing a restaurant. Your Honours, the background to the actual failure or refusal to answer questions is this. Over a period of 3 days, in October of 2004, he made a statement to an investigator from the Office of the Prosecutor dealing with his part in the events of 1998. And at the beginning of his statement, he said that he was making it voluntarily, had not been threatened or forced, nor offered promises or incentives, and was prepared to testify before the ICTY, and he signed that statement. Then he made a further statement on the 8th of December 2004, which contained the same averments as those I have just read. On the 11th and 14th of March of 2005, he testified, as Your Honours have heard, with protective measures in the case against Limai and others. He was then interviewed again between the 10th and 14th of May of 2007, this time by a mixture of lawyers and investigators from the Office of the Prosecutor, dealing with the case against Ramesh Haradinaj and others. And a consolidated statement comprising the answers that he gave in this interview and his earlier statements was produced. This was, as it were, a truncated version to reflect the parts that were thought to be relevant to the Haradinaj case. The statement was taken in English but translated into Albanian, and both the English and the Albanian statement were signed by him on the 1st of June of 2007. And he signed a declaration to the effect that he'd given the statement voluntarily and was aware that he may be called to give evidence in public before the tribunal. As regards the events that cover, or that are covered by the indictment. On the 5th of June 2007, he was called to give evidence in the trial against Haradinaj. Prior to starting his testimony, he had asked for the protective measures to be lifted. In court, having made the solemn declaration, he immediately asked to make what he called a small clarification before questioning started. He then said that he had given the statement a long time ago, had given it to throw light on the previous and continuing crimes in Kosovo, and that he had only attended court because he had been told that if he did not attend, he would be arrested and brought to the tribunal. He described those words as threats from the office of the prosecutor. And he was then asked if he wanted protective measures, and said he did not. He was given an opportunity by the presiding judge to explain his position, and he said this: "As I said earlier, I do not need closed session. Everything could be in open session. However, if you want to listen to what I said earlier, in view of what has happened in my life during the war, with the events after the war, and with the investigators of the prosecutor, with things that have happened with the investigations in Kosovo, I'm not pleased with what has happened, and I'm not able to testify. I cannot, very briefly. I cannot, not because somebody forces me, not because I'm afraid of anybody. If you, as judges, compel me to do that, I can tell you I am not able. You can take your decision, but I'm asking you and asking the prosecutors to release me, to allow me to go back to Kosovo to see my children. If you want to send me to prison, there is nothing I can do." And that is the transcript of that hearing at page 5468. That's the hearing of the 5th of June. He was given a further opportunity to answer questions, but still refused. Mr. Carnavas, who represents him today, was appointed to advise him on the basis that the Chamber warned him that they were going to issue an order under Rule 77D. It was then decided that there would be a further hearing on Thursday, the 7th of June. On that day, when the court assembled, it was informed by Mr. Carnavas and a representative of VWS that when they had gone to Mr. Kabashi's hotel the previous day, it was found he had left, leaving a note which read, "For many reasons in this court, conditions are not fulfilled for a witness to testify properly. That's why I decided not to testify and to ask from the trial chamber to release me from this courtroom and to give me the right and security to go back to my family. I tell these things with full trust and conscience and stay behind this request. Thank you. If the trial chamber needs explanations, I can give them without hesitation." And, Your Honours, it would appear that he had in fact gone to Germany and from there returned to the United States. Your Honour, that's count one. Those are the facts of count one. Going on to count two, on the 18th of October 2007, an interview with Mr. Kobashi was actually conducted by the trial chamber in the Haradinaj case by video link. He was informed he was being interviewed as a suspect and was given his rights as such, and he confirmed he didn't need a lawyer present. He was given yet a further opportunity to explain why he didn't wish to answer questions, and in particular to explain why he did not wish to, to explain what he meant by threats from the OTP. And in effect, he repeated his complaint that there'd been no investigation of the information he had provided to the police or to K4, that it was not that he was refusing to give evidence, but, as he said, from what I've been through and from observing what's occurring, I have been neither morally nor physically able to do it. He added that notwithstanding the protective measures granted to him in the Limai case, as Mr. Kalnovas has indicated, in fact, immediately after his testimony, he'd received contact and threats. He was asked towards the end of that interview whether he would be willing to answer questions if again invited to testify, possibly with protective measures or by a video link, and he said, and I quote, this is page 37 of the transcript, "No, not that I don't want to, but I cannot. Whatever the circumstances you may create for me to testify, I cannot do it. It doesn't make any difference to be in a courtroom, video link, or secret, or open. I cannot testify over there because there is nothing right." He emphasized again that he had never personally been threatened. On the 20th of November 2007, he appeared as a witness via video link. He was represented by counsel both, in fact, in the USA and here at ICTY. Before the solemn declaration was taken, his counsel informed the court that Mr. Kabashi did not intend to give evidence. And after taking the declaration, Mr. Kabashi stated he was not prepared to speak before this tribunal. And yet again, it's not that I don't want to answer the questions, but I'm not in a position to speak before you. Your Honours, those are the facts on which the prosecution bases the case against Mr. Kabashi. In respect of sentence, as I indicated, as I said last week, the prosecution does not ask for a particular length of a custodial sentence, other than to say any sentence should reflect the gravity of the circumstances of these offences. Your Honours, unless there's anything else that I can assist Your Honours with, those are the prosecution submissions.